This is the current federal tax developments for the week of July the 6th, 2026. I'm Ed Zollers, and I am again broadcasting this week from here in Phoenix. And we're going to be looking at some of the key developments that have taken place over the past week in the area of federal taxes. This week, we're going to look at the following items. First, we're going to be taking a look at an addition I made late because this came out yesterday. I'm recording this on Friday, the 3rd, or I don't know if we call this the 4th because it's a holiday. We're treating it as a holiday. So even though the 4th is tomorrow, whichever one. So we're here. I'm recording it today. So yesterday, the last work day of the week, the tax court issued a special call for briefs in the in a tax court case that involves a pre-COVID-19 tax deficiency. And we're looking at whether or not interest is truly suspended during that period, something that could have an impact. It is related to Kwong, but it's not terribly likely as far as I can see. The July 10th date is your date, but tomorrow could be your date. And we'll talk a little bit about if you have a taxpayer that had this, we're looking at a potential claim for refund. Again, so kind of related, but not quite the same as the main Kwong issues that we talked about earlier. We're also going to talk about the oral arguments in the Soroban capital tax case that is up before the Second Circuit Court of Appeals. I believe this one's second, where they're asking about the self-employment tax controversy. And it looks like we may get a third. Everybody tries to read the tea leaves after oral arguments. Well, given the oral arguments in the two cases that we've had but not yet had decided, this being one of them, it looks like we may have one court decide that limited partner under state law automatically qualifies for exemption from self-employment tax. Another one that decides that it's not a partnership issue, so therefore they don't need to decide it at all in this case because the IRS brought it up under TEFRA, and the same thing probably happens under BBA. And then now a third one that's going to say, oh, no, the tax court had it right all along, is the way people are reading this one. So that could be interesting as we look at this. Next, we're going to look up a whole bunch more ERC cases this week. In fact, we're going to have 3 of them eventually. But the first one is going to look at the case of a concern about pleading requirements, right, for the employee retention credit. Now, we're going to revisit this in a second case that, again, these cases are not being consistent, but the Tapestry senior housing case, we'll talk a bit about that. We also have one about ERC causation and essential business hurdle for RAAM, or I guess RAAM, I guess we're going to call that RAAM construction, right? We'll take a temporary break from the whole ERC issue again. This we're going to look at the Section 530 Cap A transfer tax safe harbor ruling we got this week. Something there's been a lot of discussion about, that there might be a whole bunch of 706s required for everybody that contributed anything to a Trump account. Because remember, starting July 4th, we can put money in Trump accounts for the kids. But if you did so, there was a concern that that was not a present interest gift. And we'll discover the IRS has issued a ruling that says, yeah, you're right, it's not a present interest gift. However, for the majority of people, we are going to give a special administrative waiver on having to worry about filing that 706. And we'll talk about that waiver and who qualifies for it. We also have a case on appeal, Besicorp Group, that looks at penalty supervisory approval verification in a collection due process hearing. This is for a taxpayer who had already lost their case before the tax court. The penalties were not challenged at the tax court level, but in the CDP hearing, now they're going back and saying, yeah, but IRS, you didn't go and confirm. Even though the tax court already ruled we owed these penalties, you didn't go and confirm that, in fact, the proper procedure and supervisory approval was obtained. And because of that, well, we'll talk about what happens because of that if, in fact, the IRS can't show that it was approved. But it's kind of an interesting mess, but we're there. And then finally, we're going to talk about the retroactive ERC deadlines. And constitutional challenge based on that. So again, 3 ERC cases and a whole bunch of other things, and a brand new kind of spin on the 7508A, Cap A, subsection D issue that Congress changed in 2019. And then in 2021 decided, well, maybe we didn't mean that. So we'll get back to it. Let's talk about that one right off. This is going to look at section 7508A, subsection D, and we're going to look at interest on pre-COVID-19 disaster tax deficiencies. The question becomes, was that interest suspended once the COVID-19 disaster started? And this arose in the Weplow versus Commissioner case. This is docket number 36722-21, a case that had already been decided by the tax court back in 2025. But again, when the tax court decides a case, then this whole properly compute interest and penalties goes for, IRS and the taxpayer to do and go forward. In this case, the taxpayer paid the interest as computed, but within 1 year, which there is a special, they're filing under a special section, and we'll talk about the section your clients probably got to file under, but came back and said, you know what? We think it's wrong because even though we were all pre-COVID years that were decided last year, and it takes quite a while for tax court cases to get decided, we think that in fact that interest should have been suspended. Even though, we can't anymore say we don't owe the tax. We've now agreed we owe the tax. We can't say that anymore. What we can say is, though, that tax, yes, we owed interest, and that interest kept going right up until January 20th of 2020. And then the interest stopped accruing. Nothing happened all the way until July 10th of 2023, when the entire automatic suspension under 7508 Cap A subsection D, I should say, when that finally, stopped suspending the interest. So then we picked it up again. Of course, the IRS says, no, that didn't happen. This is effectively a continuation of the issues we've talked about in the Abdo and Kwong cases, which, of course, both of which the IRS lost. And from the IRS perspective, the bad news is Abdo is a case, reported tax court case, they lost in the tax court, and we're before the tax court here. We're going to have an interesting question come up on this case right now. So let's take a look at what's going on here. Now, obviously, as I noted, the deficiency proceeding covered taxable years 2015, 16, and 17. The parties settled, right, and the court entered a decision on May 12th of 2025. So again, all 3 years well before COVID, right? Everything was there. There's liabilities for those 3 years. The IRS and the taxpayers settled the balance due. They settled out on what the balance due should be. The court entered their decision, setting the tax liabilities, again, the penalties, etc. And of course, interest needs to be computed. Interest is not really waivable, generally by the court, only by Congress. So that's usually a mechanical calculation, but now things get a little weird. The petitioners have paid off everything. They paid the entire deficiency. They paid the entire computed amount of interest, right? So that triggered a 1-year jurisdictional basically window for post-decision interest disputes under the IRC. And the motion for interest determination was filed within 1 year of decision. That's the deadline they were working under here, becoming final, satisfying the timeliness requirements, right, under Rule 261A2 of the Tax Court Rules of Practice and Procedure. Now, again, for your client, if they didn't just finish a tax court case, this isn't really where they're looking. We'll talk a little about where they're looking here, but the issue here is still one that would affect them. And the tax court realized that, and they took a special step on Thursday to deal with it. So the tax court confirmed jurisdiction, noting that a payment within the statutory window, right, appears to establish jurisdiction for a decision on their motion, under that rule, under IRC section 7481 subsection C. Now, their procedural posture hinders exclusively on whether the commissioner's interest computations, right, properly account for statutory postponement periods and standard calculation mechanics. And it's the postponement period is our issue here. Was there a period where, even though these are pre-COVID debts, were they suspended by the actions of 7508 Cap A subsection D as revised by Congress in 2019, therefore was there on the first day of the COVID national emergency, and then changed by Congress in 21, but only for disasters arising after the enactment date. Now, the IRS, of course, as we've discussed in Kwong and discussed a little bit about ABDO, their position is no, that 7508 Cap A was not self-executing, meaning it's not like, the code itself doesn't tell you exactly what you have to do. There is nothing for the IRS to add administratively. But rather that the IRS had the right to issue regs, which they did, that would have greatly limited it, and said this didn't happen. This wasn't something that was there. Okay. The taxpayers are arguing, right, that 7508 Cap A subsection D create a mandatory postponement period from January 20th, 2020 through July 10th, 2023, during which the commissioner cannot assess interest on any unpaid tax due, period. They said that was absolute and automatic under the change in the law that Congress enacted in 2019. Right? The statutory postponement derives from the president's major disaster declaration, with the incident period running from January 20, 2020, all the way through July 10th of 2023, or May 11th, just of 2023, plus a 60-day extension that takes us up to July 10th of 2023. So they specifically are relying on the cases we've all been talking about here, right? They asserted that 7508 Cap A subsection D operates as a mandatory self-executing postponement provision, and that its application is governed by the statute's plain text. There's nothing for the IRS to interpret there as Congress writ it. Therefore, they cannot use their administrative, limitations they try to impose on the reg, when suddenly somebody looked up and decided this COVID thing is going to cover everything and it's going to be a long-term, emergency. It's not just going to go away in 60 days. So, wait, that Congress didn't mean this, and the IRS tried to change the rule. Now, the Court of Federal Claims and the Tax Court have both issued decisions that have given plain text reading to what Congress did, right? That would be Kwong versus United States, right? You remember that case, 179 Federal Court of Claims 382, and the ABDO versus Commissioner case, Tax Court reported decision 162 TC 148 from 2024. They support rejecting Treasury's ability to administratively interpret or interpret via even regs this part. There's nothing to interpret. Remember, the key rule, even pre-Loper Bright, even under Chevron, if the code is clear and the language only allows for a single interpretation, the reg, if it doesn't exactly follow that interpretation, is invalid. That was true under Chevron, true under Loper Bright. There's no difference here, right? That reg was invalid under any way you read it. Loper Bright didn't change that. Again, if the code's clear, absolutely clear, there is no ambiguity. Where Loper Bright changes things is if there is ambiguity. Then we get to the best interpretation of the ambiguous clause, as opposed to what the text says, which is what we're doing here, right? Now, they did pose an alternative theory, right, saying that they had basically improperly computed underpayment, overpayment interest for 2015 and 16 under 6621, yielding net refund positions of somewhat significantly less than what they had, but they have a backup for it. Now, where these came from was, the motion to redetermine interest per Rule 261 was filed on April 10th of this year. And Abdo was a 24 case. Kwong was a 25 case. Okay, so next up, let's get to now what really happened here. The tax court recognized that the statutory interpretation question appears to affect a potentially very large number of taxpayers and may be of some importance to the tax system. We could be talking about some big checks having to be written. In essence, maybe not big checks, but enough checks is going to talk about a lot of money that could be in play under this, right? So, to facilitate, in essence, comprehensive adversarial testing, the court ordered that any motions for leave to file a brief under Rule 151-1 by amicus, amicus briefs, I should say, must be filed on or before August 28, 26. That's the deadline pushed here. The court also waived the standard procedure restriction, saying it will allow any such briefs to exceed the usual page limits found in Rule 151.1d, right? And regard any motions filed by this deadline to be timely despite Rule 151.1e. So essentially the court is asking now for people to file these. Basically, if you've got an interest, right? If you're an interest, these will mainly be filed by interest groups. We'll think of, so you may see the ABA's tax division, probably see the AICPA's tax division, etc. Various parties will file with this, advising the court on how to deal with this, right? Now, you need to go ahead and take a look at your client accounts that have outstanding deficiencies or overpayments that are overlapping these periods, right? This federally declared disaster period, particularly where the IRS, applied regulatory caps that conflict with this plain language reading. Now, your big problem here, though, is unless your client's just coming out of tax court, you're not going to be able to use the method that's being used in this case. You don't have, the options here that the taxpayer in WEPLA has, because you're not within that 1 year period. However, you need to look at whether the interest was paid within the past 2 years, and likely if there's a remaining balance. You can basically argue, if you're arguing for the refund, was it paid? But you also can argue recomputation of balance, it would seem is possible here. That in fact, here's what we paid you. That interest was improperly assessed, right? It's improperly there. That wasn't the right computation. So we already paid. Now we can only get a refund for what we paid in the past 2 years if we've now paid more than it was there. So this is where we may have a moving refund date. Right. Remember, we are under almost certainly the 2-year statute. Why we have a 3-year July 10th issue for Kwong generally is because Kwong postponed the due dates, right, for returns. Now, there may still be an issue because Kwong could still, okay, let's kind of think this through. If your client is in the position of this taxpayer and they let's say they had a tax liability, they paid interest that was accrued during the COVID period, but it was for, let's say, year 2018, right? Return was done, filed. Its due date was not extended because, that thing, the 2018 return, was due by April 15th of 2019. You want an extension, been in October. So we're way past that. Even though the statute might have gotten held up for doing something, even with that suspension, you're still going to find you're losing it too early, right? We're going to lose the statute. But if we had to file, if our due date was between January 20th of 2020 and July 10th of 2023, then July 10th, 2023 was our due date. If there was, so let's say you had a problem with your 2020 return, your 2019 return, and you did file it timely in April of 2019, even you didn't take advantage of any extensions or anything, you still had a delayed due date. So if for some reason the IRS has assessed interest against you for the period from, it would appear, in there's been a tax return and interest assessed, and tax on that, it would appear you might have a claim. And you could be looking at that July 10th, 2026 date. But as I said, if you're not in that realm and your tax comes before that date, if your due date was before that date, then you're going to be more than 3 years past your due date, right? Pretty much for certain, unless some reason has been held open for a weird reason. So you're probably looking at the requirement to be within 2 years under 6511 of the date the interest was paid. But keep an eye on this thing because there could be a lot of knock-on effects. So if you have clients that had unpaid taxes and were charged interest during that period and the statute's still open, you might want to figure out, when were these things paid, and to be able to, and how much have we overpaid, if we've overpaid, and so figure out, how much can we get back? Because the amount you can get back should be the lesser of the amount that you basically overpaid or the amount you paid in the last 2 years, whichever is less. So literally, your due date could be going away every day under the 2-year statute. And so that's what makes this more interesting. Again, we're going to have these briefs filed through the end of August. But if you have a client in this position, you probably want to figure out if they paid significant interest during that time frame. You want to figure out when did they pay it. At which point then argue for at least the relief from that. Okay, back to our regularly scheduled stuff. By the way, that write-up is only on the website. It is not in the package you can download from the website for this week's updates, because I just barely got that one together before I started recording. So next, we're going to look at, remember, the whole controversy about self-employment tax and limited partners in a state law limited partnership. So this is Soroban Capital Partners went to oral arguments. Okay, so we're going to take a look at that. You may remember this was decided by the tax court in 2023, 161 TC 310. And then that was when it decided and put in place this rule, right, where we're going to look at, what exactly did you do in the partnership determines if you are subject to SE tax. A second Soroban Partners case then was decided in 2025, TC Memo 2025-52, that applied that test against what Soroban's partners did. Soroban has now appealed that decision to the Second Circuit, and what we had was a brand new oral argument. The oral arguments came down, and we had the arguments in front of the court, the Second Circuit, which came in about a little over a week ago, is when they had their oral arguments. Okay. Now, to understand why Soroban capital litigation is important for us, you have to look at the statutory baseline of the Self-Employment Contributions Act, SECA. Section 1401A under the Internal Revenue Code imposes a tax on self-employment income, which 1402B defines as net earnings from self-employment derived by an individual during the taxable year. Net earnings generally include an individual's distributed share of any ordinary income from any partnership of which they are a member that's not otherwise excluded under 1402. However, 1402A13 contains an exception that's the point of this whole litigation. It excludes the distributive shares of any item of income or loss of a limited partner as such, except for guaranteed payments for services actually rendered. Okay. This exception was enacted back in 1977. Legislative history makes it clear that Congress wanted to target a specific mischief, let's say where limited partnership investments are being marketed to passive investors to generate artificial self-employment income, allowing them to qualify for Social Security benefits without performing services. And believe it or not, that was a thing. Actually, even today, it would still be a thing, largely because at the lowest levels, Social Security, at the lowest income levels, Social Security is a great investment. So what they could do is qualify for Social Security and Medicare, which also is not a bad thing to qualify for. They had no self-employment income or FICA wages any time in their life. They could still qualify by investing in this. That was one of the concerns. So this exception was designed specifically to exclude income that is essentially of an investment nature. However, Fast forward to 1997, when everybody viewed this a little differently. Remember, we had been through one, Social Security is going bankrupt, redo the law, change things, quote, save it forever. As we now know, forever is running out in a few years. But in 1997, so people tried to avoid paying into Social Security. IRS issued proposed regulations in 97 that would have defined limited partner based on active participation, including a 500-hour test. Now, this caused a bit of an uproar among, those in the tax community and Congress, leading to a temporary, this was what was ridiculous, legislative moratorium in the Tax Relief Act of 1997 that prevented Treasury from finalizing these rules before July 1st, 1998. This was an inherently stupid thing to do, and I will criticize this one. If Congress really meant this is not supposed to work this way, and, if you're a limited partner, you can get out of it, even though state laws have been changed, and now you can actively participate in limited partnership and not be thrown out, then you should have just said that flat in the law. But they were concerned about being targeted by, AARP. And everybody's saying Social Security is going bankrupt. You're going to take away my Social Security. So Congress chickened out. And when July 1st, 1998 came away, Congress did nothing. So while in the Senate committee report, they indicate they were concerned about Treasury administratively rewriting the law, the people that had the right to write the law decided not to do so. And this is not the first time Congress has ignored, actually doing their job. And that's what they've done. And you'll be glad to know they've continued to do it ever since. Since the moratorium expired, neither Congress nor the Treasury provided a formal definition of limited partner under 1408-13. Instead, what happened in 2011, the tax court issued the Rankmeyer case, which was a fairly abusive way of trying to get out of paying self-employment tax, right? And that case introduced a functional analysis to a limited liability partnership. Until Soroban, however, it was an open question about whether this functional analysis also applied if you were truly a state law limited partnership. That's the key. Does it apply? Now, I think Soroban also opens up a real question. If it doesn't apply to a state law limited partnership, if everything is defined by who's a limited partner and limited partnership definition of state law, what does that do to LLC members? Because they are not limited partners under state law. Ask any attorney, who's into entities, and they'll say, yeah, they're not limited partners under state law. They might say they have limited liability like limited partner, but the question we're asking here is the literal question, are they limited partner? And the answer is no, they're not. Right? Because we're getting literal here. So let's be honest where we go here. Now, Soroban doesn't particularly care, but it is an interesting side question. So let's go to the first tax court decision, the published decision in 2023. So there were cross motions for summary judgment. Taxpayer argued because Soroban is a state limited partnership and the partnership agreement designated the active partners limited partners, they qualify for this exclusion as a matter of law. State law limited partner is how you determine what a limited partner is under 1402A13. They also argued the tax court lacks jurisdiction under TEFRA to look into the individual partner's role in a partnership level proceeding. Right. Now, Judge Butch rejected this label-based argument, applying the canon of statutory construction against surplusage. One of the great terms. It's always kind of fun, when you see these terms put back in. We've had this going here, but that's one of the favorite terms that you use. Remember, under Loper-Bright, the theory is that we're supposed to determine the actual best meaning of the statute. And one of the key canons is this canon against surplusage. Every word must have a meaning. And he focused on that clause as such. Why did Congress say limited partner as such and not just limited partner? He said if Congress had meant to exclude all limited partners based on state law definition, it would have simply said limited partner. By adding as such, which he says has to have a meaning, otherwise you're violating the canon against surplusage, right? Which is a key canon of statutory interpretation that we're told is how we're supposed to deal with these things. Congress made clear the exclusion applied to only limited partner who is actually functioning as limited partner as the term was known in 1977. And that also is one of those keys, the argument that we should be using the definition as it existed at the time. The court looked at legislative history and concluded that Congress meant to exclude only earnings from a mere investment, meaning limited partner as such refers strictly to passive investors. That was the concern expressed in the committee report. Therefore, the tax court held that a functional analysis test must be applied to partners in state limited partnerships to determine if the exclusion applied. Now, on the jurisdiction issue, the tax court held that because a partnership must calculate and report self-employment earnings, any factual inquiries into the role of the partners is a necessary part of that calculation. Therefore, this inquiry is a partnership item that is properly resolved at the partnership level in unified TEFRA proceedings. Now, we're going to quickly review where we stand on the two cases that were argued before this case before the Second Circuit. In the case of the Fifth Circuit's ruling, we have a ruling. Fifth Circuit is going to follow state law limited partner definition is what you look at. Right? And we have that ruling out. And that was pretty much the feeling everybody got from the back and forth during oral arguments. That two of the three on the panel were going to go that way, which they did. The First Circuit is going on while they seem to have total skepticism about the Fifth Circuit's ruling that limited partner, means state law only, and that's all that matters. However, they, unlike the Fifth Circuit that ignored the TEFRA ruling, says, no, this is a partnership item. The First Circuit seems to be leaning toward this isn't a partnership item, so we can't rule on it. So sorry. And IRS, sorry, you're too late now to come in and go against individual partners. So I guess this is just a moot case. Don't worry about us. So that's where we stand. We have two different takes on this. At least apparently we're going to. The one we know is telling us that it should be a state law definition. The second one seemed to be leaning heavily to this isn't something for a TEFRA proceeding. And then it gets hold to, well, is it one for a BBA proceeding? And now we're going to case three. That's where we're at. But again, the first part of the tax court decision only dealt with this, what test should be applied. And it said we're going to be looking at this functional analysis test. Now, the case that went in the Fifth Circuit, Serious Solutions, that case, there the taxpayer realizing what this meant and realizing that, hey, if we're tested against that standard, nobody's going to be a limited partner. Simply conceded that if that standard is proper, none of their partners be limited partners, and then asked the tax court to rule on this issue only in their case, knowing the court was going to follow its precedent, which it did. That gave them their ticket to the Fifth Circuit on this issue. That's how Sirius got to the court before Soroban. Soroban's like third in line. Denham Capital is the case going on in the First Circuit. Okay. Now, the second decision, the tax court memo, was when they went back and tested what these partners did versus, what the test said they should do. So these were decided, this was decided in the tax court under Tax Court Rule 122 based on a stipulated record. Now, Soroban's a Delaware limited partnership and an investment firm based in New York. It had three active limited partners. The active principals, Mandelblatt, Capedia, and Friedman. Probably got a couple of names right. Friedman, I think I got right. Okay. And a general partner owned and managed by these same principals. Soroban generated massive free income from the managed funds, totaling $247 million across 2016, and 17. On its tax returns, Soroban only reported self-employment income equal to the general partner's share and the principal's guaranteed payment, about $2 million in 2016 and $1.9 million in 2017. Okay. We excluded the over $140 million of distributive shares across the 2 years that went to these partners. The IRS adjusted the returns to include the entire $140 million as self-employment income. In applying the functional analysis test, the tax court evaluated several key factors. Role in generating income, the court found the principals played an indispensable role, with Mandelblatt serving as chief investment officer and the others running trading and risk management. Number two, operational management. These three collectively managed operations, served on all key committees, and controlled hiring and firing. Number three, the time commitment of these three. They worked full-time, putting in 2,324 hours annually, and marketing materials stated that 100% of their time was devoted to Soroban and the funds, right? And key man provisions. The fund agreement stated that if Mandelblatt were incapacitated, investors could withdraw their funds, and if all three were unavailable, the funds would liquidate. Essentially, the firm will not exist without these three, right? That's what they're saying. If these three go away, there is no Soroban. Now, the taxpayer tried to argue their distributed shares represent an investment return, showing their capital accounts fluctuated. They had contributed capital in post-audit years. But Judge Bush calculated their cumulative ordinary income as a percentage of capital contributed, revealing annual returns ranging from 45% to over 290,000%. He said this proved their income had no relationship to their capital contributed, right, and was not of an investment nature. Ultimately, the judge ruled that labels cannot override economic reality. A partner labeled a limited partner who works full-time, whose work is essential, who is held out to the public as essential, and who contributes little or no capital is simply not functioning as a limited partner. Okay. Now we go to the oral arguments. On that appeal, the tax court was represented by Shay Dvorsky. Sorry, Shay. Got that. The appeal focuses on two issues. Whether self-employment tax is an individualized partner level tax, the partnership itself is not required to take account of subtitle A, meaning it's not a proper TEF for a partnership item. Again, BBA has got to be decided later. And then the substantive issue, whether limited partners in 1977 had a plain meaning under state law, having limited liability, that federal law must respect rather than inserting an active participation test. During oral arguments, the panels of Judge Calabresi, Chin, and Merriam pressed both sides. Judge Chin opened by asking whether resolving this individual partner by partner level would lead to inconsistent results, which TEFRA was specifically designed to avoid. Judge Calabresi raised a major concern about federal tax uniformity. If the tax court blindly defers to state labels, the individual states could unilaterally change federal tax liability by altering their partnership statutes. He introduced a hypothetical. If the American Philosophical Society declared that every winner of its Phillips Prize, which Calabresi had won, right, was a limited part of the society, would that change their federal tax liability? Now, the Taxpayers' Council argued that federal tax law frequently references state law defined relationships like marriage or community property, right? We see that here. I'm from Arizona, so remember that. Keep that in mind. Judge Merriam focused on the historical context of 1977. Under the 1916 Uniform Limited Partnership Act, enforced back then, that's what the states had adopted. Limited partners were legally barred from participating in controller services. She argued that the Soroban principles would not have been allowed to act as limited partners while exercising complete management. Judge Calabresi also worried that the practical administratability of the IRS's amorphous control test. Now, this is on the other side. He warned that a vague facts and circumstances test would create massive complexity and unfairness for ordinary resource-poor taxpayers. But IRS counsel argued that the facts and circumstances tests are standard and manageable in tax law. I'll agree with half of that. They're standard. Manageable, whole nother issue. Of course, one key problem with facts and circumstances test is the IRS has the presumption of correctness in their determination. And that means you've got to not just, you got to basically be able to clearly show they're wrong in that realm under facts and circumstances. But the counsel was correct. We have to do things like distinguish debt from equity. And that's super facts and circumstances. So this wouldn't be the worst facts and circumstances case we've got. We've got some bad ones. But it would be one, and it would get messy in cases. Some cases wouldn't be clear. Finally, Judge Chin noted with only $2 million guaranteed payments for $140 million ordinary income, and given the massive amount of work performed by the principals, Judge Chin said it's not a close case. I think we're going to count Chin up as one vote in favor of sustaining the tax court. When the member of the panel says this isn't a close case, that's not good for your case. Okay. You got to get both of the other two to come with you. So anyway, that was kind of a bad statement if you're that. Now, this outcome of this appeal is highly anticipated, and we're trying to see if Soroban agrees with any, are we going to get multiple circuits coming to the same conclusion, or are we going to get a fragmented mess? And right now, we're heading more toward fragmented and mess, is what a lot of people are deciding, looking at the Fifth Circuit's ruling and then the oral arguments in the other two cases. There's a concern we are going to get a fragmented mess with three circuits and three wildly different ways of resolving the matter. Okay. While the IRS is actively auditing hedge funds and service-heavy partnerships, the Fifth Circuit recently issued that same ruling in favor of the taxpayers. Remember, we told you about that before in the Sirius case. A petition for rehearing has held up their case somewhat. However, most people suspect the Fifth Circuit will not grant the rehearing and will let that stand. We'll see. And if they did give a rehearing, they would end up with the same result. Meanwhile, the Denham Capital case, the one where they're trying to decide, hey, maybe we don't need to decide this at all because the IRS brought this under TEFRA, and sorry, we're just going to skip. That's in First Circuit. Now, practitioners, the key is to look past formal labels in the partnership agreement if, in fact, this is what's going on. Right now, if your client wants to go to tax court, right, if they're going to say, I don't want to pay it, I want to go to tax court, got to tell them, you're going to lose in tax court, except in the Fifth Circuit. Every other circuit, you're going to lose in tax court. Because the tax court as a whole has said this way it should be done. Under the Golson rule, assuming the Fifth Circuit does not reverse, doesn't basically go back to an en banc rehearing, and then reverse it. Assuming that doesn't happen, then the Fifth Circuit would rule that state law labor matter. But if you're listening to me and you're not in the Fifth Circuit, at least your client's not in the Fifth Circuit, yeah, they have to understand going to tax court is going to be a loss. Right? So then they have to carry it up to whichever circuit you're in. And, probably not going to be good if you're in the Second Circuit, because it looks like they may back up the tax court, in which case then you're looking at Supreme Court. But the other circuits we may be looking at, we don't have any idea. Like I say, I'm in the Ninth Circuit, and right now we don't have a case, that's been argued, and it's getting close to a decision at the Ninth Circuit level. So we're going to have to just kind of watch that. So for right now, that's a safe route with disclosure if you're going to go the opposite way. Even if you're outside the Fifth, I think you can still disclose. I think in the Fifth Circuit, in theory, say you got substantial authority. Outside the Fifth Circuit, I think you're going to have to say, you might say it's reasonable basis, but you're going to probably have to A275, right? File form A275 and, give yourself disclosure out for the substantial understatement penalty under 6662. In case you get examined, because you're going to lose through tax court. And then you got to just look at the math of whether it's worth paying. Soroban, $140 million, it's worth paying the legal fees, even if it is just Medicare tax. Your clients may not be worth the legal fees if you're in that game. And you got to talk about clients about their audit exposure. Like I said, this is now a jurisdictional issue outside the Fifth Circuit. I'm going to tell you, you need an A275 because you aren't going to win. The IRS is going to say no if they examine you, unless you get an incompetent agent. Competent agents can solve everything for you. But you're going to lose. You're not going to win appeals, again, without incompetent appellate conferee. So, and then you go to tax court, definitely not winning there. So, if I'm sitting here with a client here in Phoenix, I'm saying, well, you're going to San Francisco, right? If you're going to win this and you don't want to pay it ahead of time, which means we're looking at years and tons of legal fees before you get a decision. So, make, the idea there. So make your decision. If you want to disclose, take the position and then decide it's not worth fighting if you end up getting examined. Fine. We can go down that path. We can use your disclosure to get you out of the penalty, which it probably will do. But otherwise, yeah, we'll just have to kind of watch it. Okay. Hey, this week we're going to do these little happy cartoonish versions. So again, on our infographic, if you're not watching this on video, you're listening to the audio, you can download our slides from the website. If you download the slides from the website, you will get the infographic here that kind of shows you how, the whole way SECA that Soroban played out, the issues that caused them to lose to the tax court, as well as what they're currently arguing about in front of the tax court and where the arguments appear to be going. Next up, we're going to talk about the Tapestry senior housing case, right? This is a case, Tapestry Senior Housing Management, LLC versus United States, case number 25 CV34-49, right? It came up here from a district court, Minnesota. The opinion came down on June the 25th, and it's an ERC case. Okay. So we're now shift our focus over to the Employee Retention Credit under Section 3134 and its predecessors, the varied predecessor via the CARES Act and CARES Act as amended. And this highlights how critical federal pleading standards are when litigating refund claims, at least in this case per this court. Now, the taxpayer here, Tapestry Senior Housing Management, LLC, operates senior living, assisted living, and memory care facilities across Ohio, Pennsylvania, and Florida. Yeah, of course, 2 states right together and one kind of ways down south, but okay, we'll take that. For quarter 1 and quarter 2 of 2021, Tapestry filed reclaim claims for the ERC totaling over $3 million. If you want to be exact, $3,046,106. They claimed eligibility under the partial suspension pathway when the COVID-19 orders issued by the governor of Pennsylvania and the Ohio Department of Health forced them to modify their operations. In their complaint, Tapestry detailed 3 specific operational changes that took place: blocking visitors and potential tenants from being able to tour the facility, suspending community dining, group activities, and social outings, and implementing strict isolation, quarantine, and testing protocols. To show these changes affected more than a nominal portion of their business, Tapestry alleged that gross receipts and employee hours associated with these prospective visits and suspended activities exceeded 10% of their gross receipts and hours in 2019. When the IRS didn't pay, right, Tapestry filed a refund lawsuit under Section 7422. The government immediately moved to dismiss the case under Rule 12b-6, arguing that the complaint failed to state a plausible claim because it did not identify the specific government orders that supposedly mandated these operational suspensions. So that was the key. Right? To understand why the court dismissed the suit, you have to look at the substantive rules of the ERC as interpreted by the court. This credit is a refundable tax credit equal to 70% of qualified wages, that was in the 2021 version, up to $10,000 per employee per quarter. There are 2 pathways to get there: a decline in gross receipts less than 80% of the 2019 equivalent quarter, or a full or partial suspension of operations due to government orders. The court emphasized that in its view, ERC is a presumption out statute. It cited a decision in R.E. J. Smith Civil, LLC. This means every taxpayer starts outside, no eligibility, and the burden's entirely on the taxpayer to prove that they fit within a statutory definition to get in and qualify for relief and get their check. Under IRS Notice 2021-20, which provides administrative boundaries, a qualifying order must be a compulsory decree from a government jurisdiction. The IRS made it clear that public statements or comments in press conferences by officials do not count as orders. For an essential business like senior housing facility, a partial suspension only exists if more than a nominal portion of the business, defined at least 10% of 2019 gross receipts or employee hours, is suspended by an order. Furthermore, physical modifications do not count as suspension unless they have a more than nominal effect of operations, meaning they reduce the employer's ability to provide goods or services by at least 10%. Voluntary actions or simple reductions in demand don't count. Got to be directly caused by the order. Okay. Now, the court evaluated the taxpayer's complaint under the federal pleading standards of Twombly and Iqbal. I love it. That's a weird name we got there. Under Rule 12b-6, a complaint must state a claim that is plausible on its face by pleading specific factual content rather than simply giving legal conclusions. Right? I'm owed a refund is not a good pleading. Why owed a refund? So the court applied a 3-part test derived from J. Smith Civil. First, the taxpayer was subject to a compulsory mandate. Second, they stopped a meaningful portion of operations. And third, the stoppage was directly required by the mandate. The court found Tapestry's assertion that its business were partially suspended due to orders were mere legal conclusions and with no presumption of truth. Again, they're saying that's what you have to prove, that in essence, and what we're going to do is going to look at what's in your state. We're going to assume it's true and then see if you met your requirements of what you have to be able to prove to be able to come to this. If it's just the conclusion, right? Hey, yeah, we did have a partial shutdown. There's no presumption there. We're not going to presume that's right. It was just basically a formalistic, basically recitation of the elements of the law. Critically, under the due to requirement of the statute, a taxpayer must establish both factual and proximate causation. By the way, we already know there are courts that disagree with that. Right? Remember, we had the Eastern District of Washington case. The order must be the but for and a foreseeable consequence of the suspension. This is where Tapestry constraint failed. They vaguely gestured toward orders from Ohio and Pennsylvania, but failed to identify them with any specificity. This left a fatal gap in causation. The court had no way of knowing if the purported orders were legally binding, when they were effective or what they required. This violated Rule 8 by depriving the government of their fair notice of the grounds of the claim. We couldn't know. You didn't connect the dots. Now, Tapestry raised several common defenses that many taxpayers use when filing these suits, and the court in this case just basically took apart every one of them and didn't buy them. First, they argued the public record defense. They argued that because the COVID-19 order is a public record, the government could easily just have looked them up or identified them by inference. Court wasn't buying it. And there is a problem with that argument. If it's so easy to find them, why didn't you find them? The court rejected the we'll figure it out in discovery arguments, right? Expecting the court or the government to guess which of the thousands of pandemic-era orders applied is nonsensical. Fostering guesswork is not a goal of pleading. Second, the plastic film defense. Now, plastic film is going to come up a few times, especially a second Mississippi court has now ruled and followed plastic film, which is a Mississippi District Court case, which held that specific orders are not required at the pleading stage because eligibility is a fact-intensive issue for discovery. Now, the judge in this case rejected this. The court got it wrong in Mississippi. And the most recent court, I'm sure you'd say in Mississippi, got it wrong yet again. They just keep doing it wrong in Mississippi, is his theory, because it puts the cart before the horse. Under Iqbal, a plaintiff is not entitled to discovery without first pleading a plausible claim. Allowing things like this to go through would allow plaintiffs to plead first and discover later, which ultimately encourages meritorious lawsuits. We don't want a bunch of frivolous suits here or people on fishing expeditions, right? They want to get the power of discovery to go fishing. Finally, the exclusive control discovery defense. Tapestry argued that they should be spared from pleading details that were outside their control. The court noted that these were state government orders, not federal ones, meaning the federal government was the only party left completely in the dark, right? These weren't federal, they were state orders. Okay. So some key takeaways, at least if you're litigating in front of a court that is skeptical. And right now, we don't know which one we're getting, right? There's some guidance here. Specific order identification makes tons of sense. By the way, in the most recent Mississippi case, they did identify 50 orders. May not have told us exactly which ones caused what, but they did identify specific orders. You really want to have the orders identified. This, again, if you're going to tell me it's so simple, then just get them there and get them into your pleading. Okay. That's there. You can't simply allege that, that the taxpayer had visitor bans or social distancing and expect the court to infer eligibility. The complaint must name the issuing authority, the date of issuance, and the exact section or language that mandates suspension. That's what this court reads. That's not what the courts in Mississippi are reading. Just keep that in mind. Secondly, the due to standards required binding mandates. You must verify the guidance relied upon was a compulsory governmental order and not a mere recommendation. Notice 2020-120 makes it clear that official statements and press releases do not qualify. Again, we know the Eastern District of Washington decided differently. But until you know who you're getting in front of, you better not assume you're going to get that other judge. And you must quantify the 10% nominal impact up front. For essential businesses, you have to plead specific facts showing how the orders directly cause a suspension that represents more than 10% of 2019 gross receipts or employee service hours. Okay. And then finally, note to litigate defensively, right? Tapestry argued the government should have filed 12E motion for a more definite statement instead of motion to defense. The court clarified that 12E is only for completely unintelligible pleading, not to cure a lack of factual details under 12b-6. So basically, essentially, you could have amended the complaint, right, with specific details why you still could before we went to this far. Okay, right, key issues. And again, we have our new oopsie, right? Why the court said no to the Tapestry ERC claims. We're doing the cute this time, right? We're doing the cute thing. So this again is another infographic showing the flaws in the pleading and the ultimate decision the court arrived at. Again, like I said, we know two courts that probably would have arrived, at least three courts probably, that would have arrived at a different decision. But then we also about just as many that would have arrived at the same decision. So right now, our guidance is, shall we say, inconsistent from the courts about how the ERC claim is going to go. No, it's not making it easier, but this is what I was complaining about when everybody just kept litigating for the home run of throwing out the IRS notice. And then apparently the theory would be they had to pay everybody, which the courts weren't buying. And it was pretty clear they would. IRS notices are not binding. They are simply the government's position. Now, the court might accept that position, but the IRS has a right to argue the law. So, trying to hit that notice and saying, no, that notice, because that notice isn't binding. It's a safe harbor. And I've said that since day one. Don't treat it as a safe harbor. But, trying to think we're going to get a home run case, we haven't got it. Man, they've been trying. And they've all lost. The home run cases haven't come. So now ERC causation, the essential business hurdle. This is RAAM Construction Inc. versus United States. Right. This came from the Central District of California on June 23rd, 2026. Is this case when this opinion came down? Okay. This case focuses on the evidentiary standard of causation under the ERC's partial suspension pathway, at least per this court in California. This taxpayer, RAAM Construction, is a California builder of multifamily housing projects based in Los Angeles County. During the pandemic, it was designated an essential business and permitted to keep working. Despite this, RAAM faced significant project delays. For the Lincoln project in Pasadena, they were contractually required to complete work by April 2020, but didn't finish till May 2022. Instead of their normal crew installing 5 units of drywall per day, they had to operate with a skeleton crew due to staff contracting COVID-19 or quarantining, which reduced their output to only 2 units per day. They also faced supply chain shortages and were ordered by a developer to shut down the project temporarily due to on-site outbreaks. Now, this is probably, I'll say right off, a relatively weak argument. Because what we're talking about here isn't really about any order. We're talking about COVID as COVID. You didn't have people because other people are out sick with COVID. That's like, well, that's not really, that's not a government order. That's called a virus just wiped out your employees, kind of took them out of the job. So that was kind of it. And again, we'll talk about the supply chain issues and also ordered by a developer to shut down because people caught COVID. Well, it doesn't seem to be drawing its line back to the orders, which I think is always going to be big. Now, RAAM filed a 941X seeking ERC refunds totaling $1.27 million for quarter 4 of 2020 through quarter 3 of 2021. The IRS initially issued refund checks for quarter 1 and quarter 2 of 2021. But on January 25th, 2024, the IRS disallowed the remaining claims for quarter 4 of 2020 and quarter 3 of 2021. Now, following an unsuccessful appeal, right, RAAM filed a refund suit under 7422. Gang, we now know what's going to happen immediately when you file this suit. If you got paid for some quarters, they disallowed others, and you file a suit, a counterclaim is coming to get the refund back, as it did in this case. They went to claw back $574,032 in refunds already paid, arguing they're issued in error, and then they moved for summary judgment on the case under Rule 56. Now, to look at the court's decision in this case, you have to look at how the court defined a qualifying government order. RAAM argued its operations were partially suspended due to three authorities: California Governor Newsom's safer-at-home mandate, LA County's safer-at-home order, and LA County's workplace guidelines. The court first clarified its role under the Supreme Court's landmark Loper-Bright decision, which ended the Chevron deference. The court emphasized while it must exercise independent judgment when reviewing IRS Notice 2021-20 guidance, considering it based on its persuasive power under Skidmore was allowed. In fact, required. Went back to the old Skidmore guidance. Looking at the ordinary meaning of order as a compulsory directive, the court split its decision. First, Governor Newsom's executive order in the LA County Safer at Home order qualified as government orders because they were compulsory mandates that legally restricted commerce, travels, and gatherings. However, the county's COVID-19 workplace guidelines did not qualify as orders. These guidelines merely describe procedures for responding to positive cases and excluding sick workers. They did not mandate closure, nor did they limit commerce. The court concluded advisory procedures, even under Notice 2021-20, do not rise to the level of compulsory directives. These are suggestions. Now, they may be suggestions that you don't want to not follow because you might end up with some legal liability, right? Remember, in the COVID period, there would be a concern, that if you force people in there and somebody got sick, something happened, you might have a liability. That would have been a concern, And obviously, the developer wasn't thrilled with having outbreaks on site. They got worried about their liability. So we had lots of things happening. Now, the government's first major defense was that RAAM denied experiment partial suspension because construction work continues and project work completed, and its net income nearly doubled from 2019 to 2021. Now, I've heard a lot of CPAs make those sorts of statements saying, look, everything went up. They weren't partially suspended. There was no way. The court doesn't buy this one. The court rejected this government argument. Look at the ordinary definition of the term. Suspend means to interrupt, postpone, defer, and partial means relating to part rather than whole. Therefore, the court held that business operations are partially suspended when a portion of the operation temporarily interrupted or prevented from complete performance. Under this standard, RAAM's evidence of running skeleton crews, staggering shifts, severe supply delays, and a 2-year project delay successfully established general disputed fact that its operations were physically suspended. And critically, the court was not at all happy with the government's attempt to use RAAM's financial success and stable gross receipts to disprove partial suspension. The court ruled that using gross receipts to defeat a physical suspension claim impermissibly collapses the two pathways of getting the ERC, which contravenes the plain language of the statute. In one case, people that are negatively infected by COVID and their revenues dropped didn't have to show connection to government orders. Right? If the revenues dropped enough, they got it. That was independent. But those people who were ordered to shut down with government orders also qualified for relief, even if I don't care how much money they made, there was no revenue limits. And the court said financial success cannot be used by the IRS to disprove a physical suspension of operations. If those suspensions are physically suspended, if they can show physical suspension of operations to a sufficient size, then they have a suspension. Now remember, RAAM's problem is connecting it to a government order. But they're saying, but they could have all-time record earnings. We don't care. They could still qualify for the ERC. Now, despite proving a partial suspension identifying 2 qualifying orders, they didn't collect the dots. They have to have a statutory causation. They have to show suspension be due to those orders. Now, the court performed what it said was a rigorous plain language analysis. Every court's going to claim this now. Just realize that as we get there. Adopting reasoning that due to requires both factual and proximate causation, meaning the order must be the but-for cause of the suspension. The court explained that the ERC is a presumption out statute, like the court we had before. Congress intended to limit relief to those directly affected by the mandates. Allowing long causal change without a proximate causation requirement would risk turning the ERC into an expansive presumption in program, which Congress did not extend. Applying a strict but-for standard, RAAM didn't connect the dots. Right? The project shutdown, let's look at that. The developer ordered the shutdown due to active COVID-19 outbreaks of the work site. Not because of the governor. Your customer said, get out of here. It wasn't because of the governor's orders. It was not because of stay-at-home orders from the county. Your customer said, I am not taking the risk that somebody comes after me, because you got all these sick people on site. Yeah, get them out of here. Supply shortages. RAAM provided no evidence showing that local stay-at-home orders rather than global supply chain conditions. Remember, we had cargo ships in the wrong place, right? We had we had Chinese government orders had a lot to do with the supply problems. But unfortunately, these couldn't be Chinese orders, right? That was one of the problems. So those global supply chain conditions and not U.S. level, state level government orders were what were really responsible for a ton of the supply chain problems. And then workplace distancing. Staggering shifts and running skeleton crews were treated as voluntary self-imposed safety measures or reactions to non-binding guidelines rather than direct compliance with compulsory orders. So they never connected the dots from a compulsory order to a shutdown, right? That was their problem. And under the Stenson-Tamadon decision, a business voluntarily suspends its own operations, acts of its own volition, not due to government orders. Stenson-Tamadon cases were some that were going after the home run case. And that one was from here. That's a group here in Arizona that were litigating that. They were one of the key litigators, in what I call the home run derby, trying to get a throw out of IRS notice, get to throw out the IRS notice and then use that as a way to get all claims paid was my theory of how the next step had to go. We never quite got there because no court was going to go there. What about the clawback in the $574,032 in refunds it already received? To recover an erroneous refund under 7405 subsection B, government must satisfy a four-part test. A refund was paid, exact amount is specified, the recovery action is timely, the taxpayer was not legally entitled to the refund. The court applied this test. The payment and the amount were not disputed by either side. So 2 of the 4 are in, right? The taxpayer received, the time of this 2-year statute of limitation runs from the date the taxpayer received the refund check, not when the IRS issues it. RAAM received the quarter one check on July 3rd, 2023, and the government filed its counterclaim on July 2nd, 2025. It barely got in under the clock, right? Since RAAM could not prove but-for causation, they had no legal entitlement to the credit, so the court has ordered them now to pay back $574,000 plus interest. Like I said, that was a downside of going to court. Given the IRS just barely got a claim in, I think it's pretty certain had they just not challenged the other orders, they would have kept the $574,000. So, right, that's their problem. And this has happened in enough of these cases. Your clients have to understand, and their counsel are going to talk about it too. But the risk of counterclaim is real. You might want to take the money and run, because we don't have a lot of reports. If I haven't heard them yet, of a lot of reports of the IRS actually auditing a ton of the claims they did before. But if you sue them because you hadn't gotten other claims, well, then they just knee-jerk will come back and counterclaim you, assuming that your support for those are probably as bad as the ones they see now. That's their assumption. So far, they've improved right. Where the courts were not happy with what was filed, they've tend to come down against these. They kind of tend to come down and said, yeah, you shouldn't have kept those things either. So be aware of that. Yep, that's it. Okay. So causation is, if a court's turning on them, causation has become a primary battleground. Can you connect the dots from a government order to your shutdown, to what happened? You got to separate advisory guidelines from compulsory orders, right? Again, many judges are going to, if this didn't legally require you to do this, that was just you deciding to do it. And you're not going to get it for that. And essential businesses can still qualify, but they have a higher evidentiary standard because, they were told they could keep operating, so they weren't fully shut down. So, they have got to show these direct causations. And finally, really important, receiving the IRS check is not final approval. The IRS has 2 years to ask for that check back. And keep that in mind when your client's considering suing for quarters that haven't been paid. Well, in this case, clearly the numbers that they hadn't been paid were way higher than the numbers than the credits they had received. That's not always been the case. Sometimes, some of these cases, as I recall, we've had somebody going after a single quarter and putting a lot more money at risk. So tell the client, watch that. And it's tough to explain to clients, well, they paid me the others, then they agreed I got it. Nothing changed. It's like, oh, they didn't really. What they're saying now is they probably paid out ones they shouldn't have. And the minute you file a claim for refund, the minute you go to court suing them for the refund, they're going to go ahead and counterclaim. And we're going to go back and actually look at your prior one. That's going to be a problem. So why partial suspension wasn't close enough? Now, like I said, pay attention to where RAAM won. This is with a court that's highly skeptical. And there are things still that they didn't like about the government's case and that they thought RAAM did right. So keep that in mind. There are some positives here, but also keep in mind why, even though RAAM actually won some of their arguments, in the end, they not only didn't get their $1.2 million refunds that they hadn't gotten yet, they had to give back $574,000 worth of refunds, which I think we can say is not a good result in court. Now, of course, the question becomes, do they appeal? Who knows? If they do, the good news for me is it would go to the Ninth Circuit. And obviously, we would love to have the Ninth Circuit on the record. We need a number of circuits on the record on this. So we'll see when we get it. So again, we have our little, like I said, infographic. You can follow that along. It is all happy-faced again. I don't think RAAM was terribly happy-faced. But, but it's there. Well, it is a little sad-faced on the sides for the losses. So I guess, it does show the sad part. It's sad versus, the good parts. But your client may be able to take advantage of the upbeat parts. Even in RAAM, where the court throughout the case, they still said government can't use revenues against us, right? And an essential business can still qualify, right? We're going to do that, right? And we did identify valid orders. We just didn't connect the dots. Okay, next up, we're going to talk about the 530 Cap A Trump account transfer tax safe harbor here on the weekend when we first start actually doing Trump accounts. Believe me, the timing's not accidental because the IRS kind of realized they need to get this out now. Revenue Procedure 2026-25, right? Issued on June the 29th. Effective July 4th, as I record this tomorrow, if you're listening to it on Monday, as of last Saturday, we've been able to make contributions to Trump accounts. But there has been a problem, many, many parties have pointed out, with the way 530 Cap A was written, and specifically what was not found in there, which is found in 529. And that is that a contribution to a Trump account is not by statute declared to be a gift of a present interest. Now, if you do any gift tax work, you've ever done anything, anything about the gift tax, you know that every year we have an amount we can give, right? $19,000 that we can give, but it must be a gift of a present interest. But if we do that 19,000, over 19 for anybody and they're all present interest, we don't need to file a gift tax return. And it doesn't reduce our lifetime transfers. However, if you give somebody something that's not a present interest, right? They can't get it currently. They got to wait till sometime in the future. That's a gift of future interest. And that always requires a gift tax return because even a dollar gift of future interest will reduce your lifetime transfer tax exclusion. So the IRS decided to deal with the problem here. Okay. Now, the Trump accounts were added in the code by Section 70204 of the One Big Beautiful Bill Act, which was signed into law July 4th, a year ago, July 4th of 25. By statute, a Trump account is a traditional IRA account established under 538 for the exclusive benefit of eligible individual under age 18, with a bunch of mods. The minor is designated as the account beneficiary and technically the owner of the account, but not the person in control of it. To be eligible, the beneficiary must be under 18 at the closed calendar year. The account is opened, have a Social Security number issued before the election is made, and have an election made on their behalf to be part of it, right? What makes these accounts unique and what creates the tax issue is the rules related to what the IRS refers to as a growth period, which is the period before January 1st, the year the beneficiary turns 18. During the growth period, Absolutely no distributions can be made from the account, with very narrow exception for qualified rollovers. And you got to roll over the entire account to another Trump account. Able rollovers at age 17, if you qualify for an able account, the child does. Return of excess contributions or distributions if the child dies. If the child lives, we don't overcontribute. The first time the child is going to be able to touch the money will be after they turn 18. If that child is 1, that's a number of years in the future. Obviously, a textbook future interest. That's the problems. Okay. There we are. Now, this annual contribution limit of $5,000 does not apply to $1,000 pilot program contributions, qualified general contributions for the governments or nonprofits, or rollover contributions. And to date, nearly 6 million Trump accounts have been set to be opened, as of the beginning of the program. So effective July 4th, or effective, well, this was as of June 4th, 1 month before, we're expecting to have 6 million plus accounts that go live on July 4th. That was the point of this. Okay. Now, following the enactment of 530A, the IRS and Treasury were flooded with comments from every organization and a bunch of practitioners regarding the gift and GST tax consequences of the contributions because these appear to be future interest. Okay. Under the default transfer tax principles found in Section 2511A, the gift tax applies to all direct or indirect transfers of property, while Section 2503, subsection B1, allows annual per donee exclusion, $19,000 for 2026. This exclusion is limited to gifts of present interest. It is completely unavailable if what you're giving is a future interest. Because the distribution restrictions of Section 530 Cap A completely bar the minor beneficiary from accessing the funds, not only the beneficiary, his guardians, nobody can access those funds. During the growth period, contributions to a Trump account are, without question, gifts of a future interest. I say, this is textbook. It's a future interest. Okay, therefore, under Section 6019 of the Code, every single donor would be legally required to file a gift tax return, Form 709, to report these transfers regardless of the amount. Assuming everybody who set up for a Trump account put some money in the Trump account, that's 6 million gift tax returns. Okay. Now, this is a potential disaster for the IRS. Because in fiscal year 2025, the IRS received 300,000 gift tax returns. Right. And if you haven't noticed, they've been losing staff. With 6 million Trump accounts, expecting even a fraction of those donors to file Form 709 would cause the number of annual returns to skyrocket to several million, overwhelming the IRS processing centers and those employed there. So, in the interest of sound tax administration, the IRS has issued Revenue Procedure 2026-25 to establish a safe harbor. Fundamentally, Congress didn't think. I wouldn't say didn't think about this, but didn't think is probably more proper. Congress fouled this up. But right now, they're in no position to pass a patch bill. Why not? This goes back to the Affordable Care Act. Right. That was the time that we really for sure started seeing that the minority party, if you pass something by pushing it through with only your votes, and issues are discovered in that thing, the minority party is not going to be of any assistance, at least without getting a nice big something in return, in fixing the problem. You cannot get this problem fixed because they didn't put it in the bill. Right? It's a problem. Now, if they get another, if they can get another bill to go through reconciliation, which is questionable. It keeps coming up. We keep hearing that they're going to try, and then we keep hearing, no, there's no way it's going to work. We'll see. If they go through reconciliation, I might be able to fix this, but otherwise, we're just stuck. And I don't see it being changed anytime in the near future. So the IRS is going to administratively change the law, which under SC tax, we told that wasn't a good idea. But by the way, it's not a good idea unless you're Congress and you realize that you can't fix it or it'd be embarrassing to fix. In which case, then you tend to turn a blind eye to IRS administratively fixing things. So we have an administrative fix here that we're going to get. Okay. Now, to qualify for this safe harbor, here's the key. And actually, as as one CPA said, basically in threads in reply to my posting that this thing's out there, he said, so we're just going to pretend this thing we don't like doesn't exist, and the law doesn't say what it's supposed to say. And he said, and frankly, I'm all for it. Again, at, in terms of good government structure and how things are supposed to work, in terms of those just keeping me from doing a bunch of dumb, useless, and doesn't make any real difference 706s or 709s, I should say. Yeah, I also am all for it. Right. So you have to satisfy 5 concurrent requirements set forth in Section 4.02 of the Revenue Procedure in order to not have to file gift tax returns. First, the taxpayer involved must be an individual. Entity donors are excluded. Now, we'll get into that. If you're doing it through anything like through a trust or something, sorry, you're not excluded. Secondly, only taxable gifts made by the taxpayer during the year, the only taxable gifts, must be cash contributions, cash, checks, money orders, electronic transfers to one or more Trump accounts, right? Each contribution must be made before the calendar year in which the beneficiary turns 18, right? So that's got to be your only Trump transfers. Third, total gifts made by taxpayer during the calendar year to each beneficiary, including both the Trump account contributions and any other gifts made to that same person, cannot exceed the annual exclusion amount, which is $19,000 for 2026. Fourth, the contributions must not generate any actual gift or GST tax liability for the year after applying taxpayers' remaining lifetime basic exclusion, GST exemption. And fifth, disregarding Trump account contributions, no gift tax return is required to be filed, and no return is otherwise filed by or on behalf of the taxpayer for that year for any other purpose, such as GST tax, portability, or other gifts. If all 5 criteria are met by your taxpayer, which most of our clients are going to meet, no gift return is required. No gift tax return is required. And the contributions are treated as completed gifts of present interest, eligible for the annual exclusion. If you meet the 5 requirements, good. We got it. That's a present interest. If you don't, it's a future interest, and you got to file the 709 and report it there and treat it as future interest. To illustrate these rules, the IRS provides some specific scenarios in Section 6 of the procedure. Imagine a taxpayer in 2026 who contributes $5,000 cash to each of 3 Trump accounts for beneficiaries A, B, and C. They also make an additional cash gift to C of $13,000. If the taxpayer makes no other gifts and does not otherwise file Form 709, the safe harbor requirements are fully met. Total gifts to C, $18,000, most of which came outside the Trump account, are below the $19,000 exclusion limit. Therefore, the contributions to A, B, and C are treated as completed gifts of present interest, and there's no 709. Your lifetime transfers aren't limited, aren't reduced by this. Now let's take a look at the consequence of failing safe harbor. Suppose the taxpayer's direct gift to C was not $13,000, but $14,500. Now the total gifts to C, $5,000 to the Trump account, $14,500 direct gifts, equal $19,500, which exceeds the $19,000 exclusion limit. Because they exceed the annual limits for C, the requirement in Section 4.02, subsection 3 is failed. The safe harbor is therefore completely lost for the entire year. Taxpayer must make a 2026 gift tax return, report all 2026 gifts. They're required to report the Trump account contributions, not just to C, but A and B as gifts of future interest. Don't tell clients this 5,000 counts against your 19. And what's worse is if you go over 19, the entire 5,000 is going to reduce your lifetime gifting and transfer at death. So don't go, if you go up by $1, you're going to basically cost you $4,999 of lost lifetime transfers, plus whatever it costs to file the 709. Don't foul it up. Okay. Now, for administrative compliance, you need to advise your clients that while they're spared from filing Form 709, they are not exempt from documenting the fact. The IRS on exam, especially for the 706, might raise the question of whether they really shouldn't have filed that year. So we should have records sufficient to substantiate compliance with the safe harbor rules and keep them permanently. These are classified as general tax records under Treasury Regulation 1.6001-1E. Okay. Because these are treated as standard tax records, the safe harbor does not impose any new Paperwork Reduction Act burdens, right? and is therefore improved under the Paperwork Reduction Act and OMB control number 1545007, if you're ever worried about that. The safe harbor is a practical tool, but clients must understand that keeping detailed records of annual gifting is mandatory to defend against any potential future IRS attacks. And they got to understand that they didn't say ignore Trump contributions entirely. You foul this up, we are paying a lot of attention to them. So make sure they understand. We have our nice little picture here, the joy of simple gifting for the Trump account safe harbor, and what you need to do to qualify in this here. Everybody here is happy because we assume you got it right, and you do it right. So again, make sure clients understand this. You want to print out this nice little chart that Notebook LM put together. Go ahead and do so, right? Should be fun for you. And so, we'll go with that. Yes, these are created by Notebook LM. So in case I've mentioned that before, somebody concerned about that? Yes, they are. And I actually used Notebook LM to help me draft things, right? It makes it a lot easier to get some things together. Okay, next up, Besicorp. This is a Second Circuit decision that the IRS will probably not be happy with, but talks about penalty supervisory approval verification and collection due process hearing after the matter has already been decided in the tax court. So we know they owe the money. They lost in tax court, and the tax court basically also said they owe the penalties. Now we're going for collection due process hearing. That's where we stand in this case. Okay, there is a strict procedural boundary between determination of tax liability and collection phase, and you've got to ignore the fact that penalty has been set down, and by the way, the taxpayer is liable for it, because the law requires you to confirm certain things if you're basically the appellate agent in this case. This case involves 6 corporate taxpayers assessed with substantial deficiencies and accuracy of penalties for participating in intermediary tax shelter transactions designed to avoid taxes. For example, the IRS assessed a $20 million penalty against Besicorp on a $50 million tax liability for accuracy-related gross valuation misstatements. The 40% penalty sounds like charitable contribution. The taxpayers initially filed petitions for redetermination of the tax court, which sustained deficiencies and penalties in full, and those decisions became final. When the taxpayers' active corporations failed to pay, the IRS filed notices of federal tax liens and issued notices of intent to levy to collect outstanding liabilities, which range from $13 million to nearly $200 million. The taxpayers requested collection due process hearings under Section 6320 and 6330, proposing $1,000 offers and compromises based on doubts as to collectability. $1,000 for multi-million-dollar liabilities, well, that might be one the IRS won't take seriously too much. Right, we're going to say that. Now, the appeals officer rejected the OICs, offering compromise and really, and sustained the collections. The notice of determination, the appeals officer checked the boxes and stated he had verified all legal and procedural requirements were met. However, the appeals officer did not actually obtain any verification from the IRS that the underlying penalties had received the proper supervisory approval mandated by Section 6751, subsection B1, which is required for them to obtain that information. Okay. Now, during discovery and a subsequent tax court appeal of the collection due process termination, the taxpayers requested all documents showing compliance with the penalty supervisory approval rules of 6751, subsection B1. The IRS refused producing documents, taking the position that because penalties had been conclusively adjudicated in the prior tax court case, that you can't relitigate the matter. The penalties are valid. Okay. No further verification was required. Notice the tax court special trial judge ruled the appeals officer failure to verify was abuse of discretion, which blocked collection of the penalties using standard collection methods. However, weeks later, the tax court published its Warner Enterprise precedent. In Warner, tax court held that where a court has already adjudicated and entered its final decision from a penalty, a collection due process appeals officer does not need to verify Section 6751, subsection B1 compliance. Okay. The Warner court reasoned that verifying collection stage would put administrative agency in a position of reviewing the court, serving no purpose because the court's prior final decision could not be set aside. They owe the penalty regardless, right? Relying on Warner, the special trial judge reversed her decision and granted summary judgment to the IRS, and the taxpayer then appealed that decision to the Second Circuit. So understand where we're sitting right now. Like I say, The tax court has final determination, you owe this penalty. The taxpayer is asking for collection alternatives using it in the CDP hearing. And the CDP officer, the appellate officer, is ordered to verify that all things were complied with. And they're saying, I don't need to do that because it's a moot point. It's a done deal. They should have raised the question in court. They didn't. Okay, now the Second Circuit in this case agreed with the taxpayer. They reversed the tax court, rejecting the Warner rule entirely. So Warner is not good law in the Second Circuit. Unless the Supreme Court reverses or the Second Circuit reverses itself later. The court focused first on literal mandatory text, section 6330, subsection C1, which states the appeals officer shall obtain verification the applicable requirements of any applicable law have been met. The use of shall makes the command unmistakably mandatory, and section 6751, subsection B1 is clearly an applicable law. The IRS argued the verification no longer applicable under section 6330, subsection C1, because the taxpayer's liability was already conclusively determined, and section 6330, subsection C2B, bars taxpayers from challenging liability in a CDP hearing if they had a prior opportunity to do so. The Second Circuit rejected the preclusion arguments on two grounds. Verification is distinct from liability. Citing Fetzer, the court held that a verification challenge and a procedural checkpoint, not a challenge to the existence or amount of the underlying tax liability. Because verification obligation does not attach until the collection phase begins, we're not relitigating anything, right, at this point. The IRS had no obligation to verify this before. There's now an obligation there, right? And it's an independent administrative duty. The verification duty is a freestanding statutory obligation of the appeals officer. It exists whether or not the taxpayer raises the issue. If the taxpayer is precluded from raising the issue, the appeals officer has an independent duty to check the record for compliance. Okay. Now, there's a weird distinction here you've got to understand between liability and procedural collection. The court noted this ruling does not affect the taxpayer's own liability for deficiencies and the penalty, right? The debts remain validly assessed. The taxpayer still owes this amount to the government. What the IRS loses permanently is the ability to use its expedited collection tools, specifically the filing of federal tax liens and the use of levies to collect the penalty portion of the debt. Once collect the penalty, it must go through a traditional non-expedited legal channels, filing a complaint U.S. District Court to reduce the debt to judgment, and then using traditional state remedies to collect on that judgment. Furthermore, the court left no room for the IRS to cure the issue in this case. Well, under Hoyle 2, the appeals officer can normally supplement the record on remand to show a proper written approval was obtained before the assessment. Here there was a dual failure. Not only did the appeals officer fail to verify, but the IRS failed to show the written supervisory approval was ever obtained. Under CHI, supervisory approval must be executed no later than the date the IRS issued notice of deficiency. Because they failed to do so, the error cannot be cured retroactively on demand. On remand, therefore, IRS is going to have to, they can take actions now. They have to essentially go to court, right? Collecting the penalty is going to have to require them to get that $20 million. They are not going to be able to use liens or levies. Going to have to sue them in district court, reduce the amount due to judgment, and then use state law standard collection, just like us poor peasants, and have to use that to try to get the $20 million. Okay. Now, there's a number of things to take from this because it's kind of interesting. First, always demand proof of verification during a CDP hearing. The appeals officer cannot satisfy their statutory verification duty by simply pointing to the prior tax court decision, at least in the Second Circuit. Remember, the tax court's position nationwide is they can. So outside the Second Circuit, expect to be told by the IRS, now we don't have to do that. Okay. But in the Second Circuit, they must pull the administrative files and obtain actual documentation showing that written supervisory approval was signed before the penalty determination. My guess is the IRS may tell their appellate conferees now to do that. Because while the tax court might not require it outside the Second Circuit, my guess is, does the IRS really want to create another case somebody can take up to another circuit and start losing this nationwide? I have a feeling no. Secondly, saying it was litigated before is not a defense the IRS has on verification challenges. Even if a client is fully litigated and lost penalty challenge or signed a stipulated decision, their representative can still block subsequent lien levy actions on the penalty portion if the IRS fails to verify that the section 6751 subsection B1 compliance through the CDP hearing. Finally, keep in mind defeating a lien or levy does not extinguish the penalty debt. while forcing the IRS to litigate in district court buys the taxpayer substantial time and creates a pretty big hurdle for the government, the substantive liability remains. The taxpayers must weigh the tactical benefit of blocking expedited collection tools against the reality that the client's underlying liability remains very much legally binding. If they go to court, they're going to get it. Probably going to get the court. It's going to be reduced to judgment. So you got to decide if this win is going to be enough to discourage them, and that's going to get them. They're just going to ignore the penalty, or if they're going to decide to go after it anyway. And I guess in this case, Besicorp is going to find out which way it went. So again, we have our fun, happy, whatever, what we say, kids version of the Besicorp, a cute guide to tax penalty protection. Again, just illustrating what went through on this case on a nice little cartoonish version. Okay, next up is retroactive ERC challenges, ERC deadlines. And we've seen a few of these challenges in the challenges to Congress retroactively in one big beautiful bill, cutting off ERC filing claims, including saying claims that were filed which at the very time they were filed were timely under the law that exists at that point, are retroactively been filed too late. That's a challenge that came up. And in Key Meetings versus United States, which was a case heard in the Northern District of California in June of 26, and an earlier case from the Court of Claims in 2026 called Juggler Dave and Friends LLC, we discover that, Congress can change the law retroactively in this case. Now, like I said, this is the catch. It applies only to the third quarter of 2021 claims for the employee retention credit. Okay, it basically provided a retroactive deadline of January 1st, 2024 for all claims seeking the ERC for quarter 3 of 2021. As you may remember, the House passed a bill in January of 24 that was going to cut off claims as of January 31st. You may remember that, there was a bit of a rush by some people to get their claim in by January 31st. But again, the Senate never passed that bill. So some people basically, and obviously a number of ERC consultants continued then to push and get claims filed. What we're going to look at now is what happens to people who did file after January 31st of 24, before July 4th of 25, when Congress, retroactively decided to cut them off. Can Congress do that to them? I mean, they had a claim that went in that on paper was valid, and Congress retroactively made it invalid. Now, this provision overrode the normal 3-year statute of limitations, 6511, stating no credit shall be allowed and no refund shall be made unless a claim was filed on or before January 31st, 2024. Now, this caught many late filing taxpayers in its net. Taxpayers filed after January 31st, 2024, ignored the fact that Congress was trying to do this in January 24, decided they didn't do it, so we're safe. And so they filed within this statutory window. The law was never changed. They had their claims barred. This prompted aggressive constitutional lawsuits, I should say, under due process clause of the Fifth Amendment, which have now been evaluated in 2 major cases. Key Meetings, which came out this week, and Juggler Dave and Friends, which came out back in March. Okay, let's look at the facts of the Key Meetings case, right? The plaintiffs, Key Meetings, Inc., is a corporate event planning company in San Francisco on August 24th of 24. So essentially, we're looking here, they're filing it now out here 7 months after, or almost 7 months after the January 1st date, which it was going to be cut off, right? Did Congress pass that bill? So they're filing here in August of 24, which, by the way, and this hurts the sympathy clause. That's basically nearly 3 years after the supposed, employment, the incentive this was supposed to provide to keep people employed in the third quarter of 21. Okay. But they filed this 941X seeking refunds totaling $175,000 across the first 3 quarters of 21, including $56,000 specifically for the third quarter. At the time of filing, Key Meetings met the substantial eligibility requirements, get that out of my mouth, and was within the existing limitations period for all the quarters. However, because they filed in August 24, their Q3 claim has now been retroactively barred by the new OBBA deadline. OBBA deadline. Get too many B's in there. Get the right numbers, I should say. Which set the cutoff of January 31st, 2024, which is nearly 7 months before they filed the return. The IRS is refusing to process their third quarter refund. Key Meetings filed suit in federal district court claiming the retroactive cutoff was unconstitutional under due process clause. And Key Meetings raised several arguments in this case. Hey, constitutional law. Always fun when we get there. The court could not resolve constitutional balancing on a motion to dismiss. So it was improper for the IRS to go this on the IRS's motion to dismiss their claim. The cutoff was arbitrary and bore no rational relationship to preventing fraud, as it excluded valid claims along with fraudulent ones. Congress had more narrowly tailored tools to combat fraud, such as extending audit periods and increasing, promoter penalties that they could have used in lieu of this straight cutoff, and they did those too as well. They had a protected reliance interest because they relied on the old deadline to retain staff they otherwise would have laid off. Okay. Presumably that was staff they would have laid off in 24. Apparently, they were thinking they were going to get this money, so okay. And the 16-month retroactive period was excessive and unconstitutionally severe. So what did the court say about this? Senior District Judge William Orrick applied the long-established due process standard for retroactive economic and tax legislation. Our Supreme Court's Carlton decision, retroactive economic legislation satisfies due process clause if it is supported by a legitimate legislative purpose furthered by a rational means. Now, the court says this is a highly deferential standard. The court noted the retrospective economic legislation only needs to survive rational basis review to pass constitutional muster. While retroactive laws face an additional due process barrier, that burden is met by simply showing that the retroactive application itself is justified by a rational legislative purpose. And under the Ninth Circuit's precedent, the court asked whether the retroactive application itself serves a legitimate purpose by rational means. Importantly, Congress's actual intent is constitutionally irrelevant. The statute passes rational basis scrutiny if the legislature could have concluded rationally that the facts warranted a response. The court easily resolved the case on a motion to dismiss, holding that Section 7605, subsection D of the Act, passed rational basis review. Key Meetings did not dispute that combating ERC fraud is a legitimate purpose. Taking judicial notice of congressional records showing that claims filed after January 31st, 2024 has a significantly higher rate of fraud than those filed before, the court ruled the January 31st, 2024 cutoff is plausible and rational response because it bars a class of claims Congress believes was highly likely to be fraudulent. Now, Judge Orrick's decision in Key Meetings relies heavily and was persuaded by the earlier Court of Federal Claims decision, and that was actually in May, I should say, right, in that case, or I guess it was March, in Juggler Dave. Juggler Dave, an Ohio business, filed Quarter 3 2021 ERC claims on May 1st, 2024. Which, of course, were similarly barred by the retroactive cutoff. They weren't as late as Key Meetings were, but they're still, in that period. They also challenged a 16-month retroactive active period under the Due Process Clause. However, the Court of Federal Claims applied the Federal Circuit's 5-factor GPX balancing test. So let's compare how the courts analyze these factors. Wholly new tax. The Court of Federal Claims rejected the claim the cutoff was a wholly new tax, which faces higher scrutiny. Wholly new tax imposed a new liability on completed transactions, whereas this cutoff merely restricts access to a previously available credit. Wasn't a tax. 2, curative and remedial. Both courts found the law was curative and remedial because it was designed to combat widespread fraud and protect public revenues. Because this rate of fraud was unanticipated when the ERC was enacted, Congress attempted to cure the newly revealed flaw. How about the 16-month retroactivity period? Both courts agreed a 16-month period is constitutional. There is no fixed constitutional limit on retroactivity, and courts have routinely approved longer periods, including the 14-month period in Carlton, a 4-year period in Licari, and a 5-year period in GPX. Notice and reliance. Both courts held the widely publicized IRS moratorium and pending legislative bills in 2023 put taxpayers on notice of potential changes, eliminating any legitimate reliance arguments. You were on the record, warned. They were planning to cut it off as of January. If you were relying upon it, if you didn't get your claim in by that date, remember, what led to the claim were actions that took place in back in the third quarter of 21. And we're looking here in 24, right? So we had over 2 years, right? And coming close to 2.5 years after they got qualified, the events that would qualify them took place. They had a long time to file that claim, and they didn't. And if they really had relied upon it that much, and they were after it that much, they really should have filed that claim by the January 31st date that was being bounced around. Now, for tax practitioners, these rulings establish a precedent. Retroactive changes to tax credits face an extremely low constitutional hurdle under rational basis reviews per the Court of Federal Claims and the District Court applying precedents from their circuits. The federal government enjoys broad latitudes to retroactively limit or eliminate tax benefits to prevent fraud and protect public revenues. Under Carlton and GPX, the court's not going to second guess the narrow tailoring or efficiency of a legislative cutoff. If Congress believes a class of claims has a high rate of fraud, a broad cutoff is constitutional, even if it sweepingly includes valid, non-fraudulent claims. The fact that some of those claims are valid is irrelevant. Furthermore, detrimental reliance is insufficient. Waiting years to file a claim, nearly 7 months for key meetings, and over 2.5 years for Juggler Dave, undermines any reliance interest. Okay. Finally, advise clients that tax credit and relief programs remain administratively active and subject to retroactive legislative amendment or termination until their claims are fully resolved and paid. Neither the Constitution nor precedent guarantees a vested rights to tax credits or guarantees perpetual reliance on prior tax laws. Act now. Okay, that's key. And again, our nice little cartoon illustration, if your client needs to be made happy after being upset about this retroactive change. We have here our retroactive ERC deadline and why the courts found it is legal. It's a rational basis rules, and it can be done retroactively. That's simply the way it works in this case. Well, this has been the current federal tax developments for the week of July the 6th. My slide says June 29th, but it was July the 6th, 2026. If you have any questions, my email address is on the slide at zollers@currentfederaltaxdevelopments.com. I also will be on the Connect sites for the AICPA now. I'm on theirs. That they have a Connect site of sorts set up for the tax section, so tax provision. So I'm in there that one. We also though have on the sites for the states of Arizona, New Jersey, Minnesota, Illinois, Idaho. We're all in there. Washington. If you have any questions, you post them there, and I see them. I will see about responding. Otherwise, we look forward to seeing you guys come back next week. Now you got to get used to a fact that we're going to have now full weeks until we get to Labor Day. So, you got to get through. There are no more holidays. We've been through Memorial Day. We've been through the 4th of July. Our next, basically 3-day weekend is Labor Day. So at least the 4th this year became a 3-day weekend. So we have that good. But otherwise, we will see you next week when we talk about what happens in the coming weeks in current federal tax developments.